Next case on the docket is DUVALL versus DUVALL.
May it please the court. My name is Harry Hackney. I'm from Tavares, Florida, and law firm of Campione and Hackney. It's my pleasure this morning to represent the appellant Pamela DUVALL Campione in this particular matter. As I was discussing the case and appellate matters in general with Mr. Wendell prior to our coming in here this morning, we were discussing the joys of appellate practice, and Mr. Wendell said he particularly enjoyed the intellectual challenge and the fact of being able to argue cases like this that present novel issues. I submit to you that that's the problem with this case, is that there is nothing novel about this case. The fact that we're here arguing these matters that should have been decided separately or differently in the trial court, I think is symptomatic of the whole problem here. We have two parties who were divorced 13 years ago, number of motions for contempt. As the trial court judge found, Mr. DUVALL was consistently late with payments, consistently failed to make payments. Ultimately, this resulted in the filing of a motion on or about April of almost 2 years ago, next week, April 18th, 2014. And this motion was to enforce a settlement agreement.
How did you label, how was the motion labeled?
I believe the label was motion for indirect civil contempt and enforcement, which was the same thing that the previous four had been.
You would characterize that as merely a motion to enforce the agreement and not invoke the contempt powers of the court? Is that what
That is correct, Your Honor.
What was your demand for relief at the end of the motion?
The demand for relief asked for, I have it written down here. It did ask for incarceration, but also asked for granting such other relief as permitted by the stipulation and under law. And attached to that motion was the affidavit as Exhibit A, which was incorporated therein. And if you look at the Exhibit A that's attached and incorporated within the motion itself, it very clearly says, at I believe paragraph 8 of the affidavit, that what the appellant was entitled to was the entry of a judgment in the amount of $250,000, less approximately $18,000 in change in payments, for a total of $231,000 at that time. And that was attached to and made a part of the motion. It was also clear throughout the litigation that what was being sought, in accordance with the terms of the stipulation, which was quoted at length in the motion, was the entry of a judgment. And if you look at the motion itself...
Did the motion invoke the contempt powers of the court or not?
Only if you allow the heading at the top to control all of the portions. It was a fairly minor part of the motion.
It was also in the prayer for relief, right? You couldn't be asking for incarceration if you weren't invoking the contempt powers of the court, could you?
That's true, but we were clearly asking for the entry of a judgment, and that's all we ever asked the judge to award. And we made a general prayer for relief for all relief that we were entitled to under the law and the stipulation that we were seeking enforcement of.
Was the only specific relief requested the incarceration, and the other is comes under just the general and all other remedies available? Or did you ask for anything else specifically in the relief other than incarceration?
It did ask for incarceration and a purge amount, and then the general relief. So specifically, I think I would have to concede that you're correct. That was the only thing that was specific within the prayer for relief, other than the general prayer.
Made in the relief motion was the contempt power. It wasn't simply the entry of a judgment, right?
Well, I would have to disagree, and the reason I would have to disagree, although you're correct about the addendum clause of it, is that if you look at the entire body of the motion, beginning with paragraph 1, where we note the order accepting and filing the stipulation and order approving, paragraph 2, where we quote at length from the stipulation, paragraph 3, which alleges the failure to pay, paragraph 4, where we quote paragraph 2E, and the fact that failure to pay within 7 days results in the entry of a judgment for $250,000 less the amount paid. If you consider the motion as a whole and all of the multiple paragraphs, one right after the other, that allege the stipulation and the relief allowed under the stipulation, you're kind of letting the tail wag the dog if you look only at the addendum clause and you ignore the general prayer for relief.
Well, you could have had those same facts in the motion support a motion for entry of final judgment and a wherefore clause asking for entry of final judgment, and use those same set of facts to support a document titled motion for contempt and a request for incarceration and a purge amount, correct? I mean, you could have used those same facts, the same background facts for either motion.
No, I would have to disagree with that. And the reason why I have to disagree with that is because the stipulation, which was quoted, was quite clear as to the relief that would be allowed in the event of a breach. And although we are dealing with a family law case, and in some instances incarceration and a purge amount is appropriate, it's well-established law that in family law cases, and I cite one of those cases in my reply brief, that a party is entitled to judgment for past due amounts, and it has nothing to do with whether or not the person has the present ability to pay or other contempt relief that may be involved in such a case.
So if you had obtained a judgment as you had requested in the alternative, arguably in your motion, is that a judgment that could have been enforced by contempt or simply by normal civil execution?
It would have been normal civil execution. It would not be enforceable by contempt.
Would it be dischargeable in bankruptcy, for example, because it's just a straight civil judgment?
Of course, now, the problem, I believe, in bankruptcy court as to why it may not be dischargeable has nothing to do with contempt. I believe it's probably not dischargeable in bankruptcy because it would deal with support obligations, although ultimately that's a question that the bankruptcy court would have to deal with. I don't practice bankruptcy law, but it's my understanding that support obligations would not be dischargeable. And as far as this idea that Judge Takis raised that somehow this past due amount that the mother had already advanced on behalf of the support of her children and therefore was owed is somehow a waiver of support for the children, I would point out that of the $640,000 that was being sued for or was being sought as part of the fourth motion for contempt, the one before this one, that less than $200,000 of that was child support. So the $250,000 judgment would have been more than enough to reimburse the mother for the child support, as well as the health insurance and other obligations that were due.
Now, was there argument made at the hearing about whether or not, if in fact there was an arrearage here, it was in good faith or a good faith belief that the payments were being made in advance rather than in arrears?
There was, and in fact, the judge made a specific finding about that, which, if there is a unique quality to this case, is the fact that when it comes to the pertinent facts, the judge actually found the pertinent facts in favor of the appellant in this case, because there was that argument made and the court expressly rejects that. Judge Takis says, I think his exact language is something like, to put it mildly or to say the least, he was repeatedly delinquent and he was again this time, and that's specifically in the order, that declined to enforce the stipulation as written. The judge specifically finds, I think, no less than 3 times that he disregarded and found expressly against any argument with regard to the late payment, although with regard to it being in good faith or a result of mistake, the judge does find that it was a mistake on the part of Mr. DUVALL. Yes, that's true. And the court gives him what I call the mulligan. You've been a bad boy, don't do it again. You made a unilateral mistake. And if you look at the terms of the stipulation, it says specifically, the only excuses are an act of God or something beyond your control, such as a bank error. Gosh, I made a unilateral mistake in terms of when my payment was due, does not give you a free pass, specifically not with what the parties agreed to. And if you look at Huffcore versus Gulfstream, the court says, a party who's owed money is due nothing less than the payment of that money on time, particularly where the agreement makes time of the essence, which this stipulation did. So, yes, the court did find that Mr. DUVALL made a mistake, but I would submit to you that making a mistake is not grounds for relief, particularly not the way this stipulation that the parties negotiated and entered into was agreed to or provided for. So with regard to that, I think that answers that particular question.
And was there objection raised to any evidence as to whether this was a good faith mistake? Was the argument made at trial court, judge, that's not admissible, this is irrelevant, unless it fits under what the contract calls for, you shouldn't even accept testimony on it?
The argument made longly, loudly, and repeatedly was, Judge, mistake doesn't matter, this agreement is clear. And regardless of whether or not that evidence should have been excluded, and actually, if somebody's going to come in and make that argument, it may be barred by the agreement. I don't know that necessarily makes that argument inadmissible for the purposes of putting it forward to the court. That is what the claim was. Actually, the claim wasn't even, I made a mistake. The claim was, I made no mistake at all. I was a month ahead at all times. And the court expressly rejected that argument that he was a month ahead at all times. I mean, the argument wasn't and still isn't and isn't in the briefs, oh gosh, I made a mistake. The argument is, I didn't make any mistake. I was a month ahead. And the court the trial court expressly rejected the argument that he was a month ahead at all times and found that he was in fact late, and there was competent substantial evidence, which the court states in his order, there's competent substantial evidence to support the fact that he was not a month ahead. And then I think not so much based upon an argument made by Mr. DUVALL, but the court on its own says, well, he's mistaken as to having been a month ahead. Not because he argued he was mistaken, but because what he argued was, I was not behind. And that was the argument that was made consistently and repeatedly right up, as I believe I say in my brief, until the bitter end, and is still being made in the briefs today, is notwithstanding this finding of the court, which of course should be given discretion, because it's a finding of fact, I was not late, I was a month ahead. If there are no further questions, I'd like to reserve the remainder of my time for rebuttal.
About 7.5 minutes.
Thank you.
May it please the court, I'm Andrew Wendell on behalf of Stephen DUVALL, the appellee and former husband in this matter. To begin, this is a case about a payment due of $1,250. That is the sole enforcement issue that was before the court. It was the only one pled in the motion, and it was the only one that the former wife testified to. She specifically testified at the hearing that that was the only breach that was at issue. The $1,250 at issue was alleged to be 11 days past the grace period, meaning that she is asking for $180,000 as a penalty for a $1,250 payment, 144 times the amount of money at issue, or otherwise stated, if you were to compound this.
How did that number come about?
That number was simply a number that was inserted into a contract to create a deterrent to breach of the contract.
But I mean, wasn't that number a function of the aggregate that would have been due anyway under the judgment?
No, Your Honor, it wasn't, because what happened was Mr.
Or less, actually, than what would have been due under the terms of the judgment.
I actually know that as well, Your Honor. There was never a judgment for any greater amount. There was merely a situation years before this contract ever came.
But if you add up all the arrearages and all the payments that were due, what was the total of that amount?
To be clear, there were no arrearages due because Mr. DUVALL had independently sought modification off of the basis that he became unable to work, he lost his business, and he filed bankruptcy. He sought a modification, and there was...
Well, I mean, there was a bargain for number, $180,000. You mean to tell me that you all just pulled it out of the ether, or what? I mean...
Well, I will say that I was not a part of the case at that time. I was not Mr. DUVALL's counsel.
The record reflect is the... How do I know from looking at the record that it's a penal sum?
A penal sum because it has nothing to do, because when you look at whether or not it's a penal sum, you're looking at whether or not the instant breach gave rise to that possibility of a damage.
I don't think so. You owe somebody $500,000, and you reach an agreement that you're going to pay them $250,000 in payments, but if you miss any payment, you're going to suffer a judgment for the whole $500,000. That's not penal. So how do I know from this record and the evidence that was before the trial judge that this particular agreement was penal in nature?
Because you're presuming a fact that's not in evidence, Your Honor. What you're presuming is that
I'm not presuming anything. I'm looking at the record. Where did your client establish in the record that the $180,000 was a penal sum?
He did, Your Honor, because the defense was that at the time that the allegation was that there was $647,000 due, there was a pending request for modification. There was no vested arrearage because it was subject to modification. It was a support obligation, which is always in the jurisdiction of the court. And so when we come to this figure of $647 that Mr. Hackney is relying on, stating that it's within the range of litigation outcome, it was not, because there was not litigation on that particular issue that's before the court today. What occurred...
I don't really think that's your best argument. I think your best argument is the issues that Judge Palmer's been talking to counsel about, which is, whether counsel invoked the contempt powers of the court. So why don't you address that?
Absolutely, Your Honor. If I might start there, then the wherefore clause has been correctly identified as something that is significantly at issue. Now, Mr. Hackney's been good enough to point out that there was an affidavit that if it was accompanying the motion itself.
Does a motion for contempt invoke the equity side of the court or the law side of the court?
The motion for contempt absolutely invokes the equity side of the court because it's a discretionary power of the trial court, which they have, that's before them, and that they have to use with great care. The motion for contempt, it was specifically pled that the amount of the escalation, that $180,000, was directly tied to the purge amount in the wherefore clause. There was no pleading in the wherefore clause that made a specific request for any liquidated judgment other than the purge amount, and it specifically states, in order a purge amount and/or incarceration of the respondent, which awards petitioner $218,000 in change. It was specifically tying the figure from the affidavit, and all of those figures, all of the other references to the math that was being done and that was referenced in the motion, all relate to this wherefore provision and specifically tie it together with a request for a purge amount. But there was never any evidence of ability to pay. There was never any evidence presented that he was presently in non-compliance because it was acknowledged by both the former husband and the former wife that on April 18th of 2014, the very date that the motion had been filed, the records of the clerk of court demonstrated that a payment had already been received and had already been processed at that point. So to the extent that Mr. DUVALL, the former husband, was not already one payment ahead, he was in a situation where he had cured it as of April 18th, and there was therefore, because this is a request for a civil contempt matter, there could be no sanction in terms of an escalated amount, because that would have been punitive in nature, and to do so would necessitate the trigger of a criminal contempt action as opposed to a civil contempt action. The criminal contempt action had not been pled, there had not been a show cause hearing, it was not relief available that had been sought at that point in time. And given that the purpose of civil contempt is to compel compliance, and compliance had already been achieved. It was not a remedy that the court had the discretion to utilize, and certainly not a remedy that the court abused its discretion in not utilizing. So in terms of the court's ultimate ruling, the trial court's ultimate ruling on this point of contempt, it goes further than this as well, because the trial court itself, when viewing this issue, indicated in the motion for a hearing that they thought what had been presented to them was a contempt request. That was expressly what the trial court understood this to be, not just from the
Your
pleadings.
client filed a motion for appellate attorney's fees?
He has, Your Honor.
What, on what basis?
On the basis of prevailing party.
Did you prevail under the settlement agreement, or did you prevail in a hearing on a contempt?
What we indicated, and it was only for appellate attorney's fees. There was no trial-level attorney
Can
fees.
you really have it both ways? I take your central argument to be that that the motion was for contempt and that the trial judge had the discretion to deny it, notwithstanding the literal language of the agreement. And then can you turn around and seek fees under the agreement on appeal?
Well, I believe the reason for that, Your Honor, is that the contract was not invoked. The contempt remedy was an election of remedies issue at the trial level. The remedy elected was contempt, and only upon contempt being denied did that evolve to, no, we're seeking the monetary judgment enforcement aspect as opposed to that. And so Mr. DUVALL, having had this matter brought forth to the appellate court, did seek only at the appellate level under the prevailing party fee provision in the event of prevailing at the appellate level. Now, he did not seek at the trial level a prevailing party fee provision, which was something that had been sought by the former wife, in which was largely rightfully denied, as she was not the prevailing party at that level, as she did not have her $880,000 invoked, and that is the substantial issue before the trial court. However, in addition, to the contempt basis, there are 4 other independent bases outside that. I'm certainly happy to talk about contempt more as well, but there are 4 other independent bases which result in the same, which are all independently dispositive. And as Mr. Hackney has pointed out, the former husband maintains that he was not late on payment. He maintains that it's not just a mistaken belief that he was ahead in payment. And I do not believe that the record supports that there's competent substantial evidence that he was ever behind in payment, because of the fact that when it was testified to, Mr. DUVALL, the former husband, was exceedingly clear in how and when and why he made that payment. He made it because in November of 2012, when the very first payment was due, and mind you, between November of 2012 and the very first payment was due, in 2014, when this issue arose in April of 2014, there had never been an allegation of any other late payment. There had never been any tardiness with payment, and Mr. DUVALL indicated that he wanted to remain ahead on the payments for fear of that penalty, because the penalty was actually acting as a deterrent to him. And he made the payment through the state disbursement unit originally. The state disbursement unit had not yet set up the account. So as a result of that, it was returned to him. In the interim time, he made a payment directly to the former wife. The former wife acknowledged receipt of the payment to her. She acknowledged that he did make one independent payment to her. She then was unable to provide any competent substantial evidence as to other payments, because she had been testifying from a handwritten piece of paper. It was scripted for her, and when she was told, there was objection repeatedly to the use of that. She was told she would have to testify from memory, and once that paper was set aside, she was then to the point where she couldn't remember the most basic facts, such as Mr. DUVALL's allowable grace period or the manner or amount of payments that he had made. And as a result of that, there wasn't competent substantial evidence of the breach, but Mr. DUVALL, on the other hand, testified that he not only testified that he made a second November payment to her.
Did you cross-appeal on the trial court's determination that your client was in breach?
No, Your Honor, I raised this an issue of...
How can you argue to us today that argument? That's not before us, is it, if you didn't cross-appeal it?
I argue this today because it's harmless error. If you view this in terms of, if contempt was not an appropriate resolution of this case, would there have been another dispositive resolution that's before the court on its face? And I believe that it's harmless error with respect to this. But moreover, aside from the payment, there's also another premise where the former wife simply didn't meet her burden with the relief she is requesting, because she asked for a liquidated amount of funds, but she never proved what that liquidated amount is. How can the trial court give her a money judgment for a certain sum when that sum remains unknown to this day, even after rehearing? There's a situation where it's acknowledged by the former wife that the payment...
Did you make that argument in your brief? I don't remember seeing that.
I did, Your Honor. If you'd like a specific reference.
No, that's okay. If you say you did, you did.
Yes, Your Honor, I did.
And did you make that argument below?
At the trial court?
Yes.
Yes, Your Honor, the argument was made in a similar form to this, Your Honor, that there hadn't been competent substantial evidence of that point of how much the judgment would be asked for, and the judge actually expressly ruled on this point too. If you look at the order, there's expressly a finding that he doesn't know how much the judgment would have been entered for. And so as a result of this, Your Honor, because what happened was the former wife acknowledged that the payment deficiency had been cured, and it was never refuted that Mr. DUVALL not only paid, but paid ahead. And I'm not talking about November of 2012, I'm talking about after the breach was alleged. He once again continued that pattern of attempting to pay ahead and testified that he made multiple payments ahead. So we don't know because this all happened between the time the affidavit was filed and between the time of the hearing, and it was all testified to at the hearing. So there was no discernible evidence, no competent substantial evidence as to how much money the judgment would have been entered for if it was allowable. Likewise, we don't even know the interest rate to be assessed because all that was ever stated was the highest allowable legal interest rate. That's nebulous. That could mean a lot of different things, and there was no argument presenting what exactly that was. So while basic computation of math, certainly the trial court could have done that on its own. But if you don't know the interest rate, if you don't know the timing or the amount of the payment, if those things haven't been presented to the court, the only thing that's known to the trial court is that payments, yes, they were in fact made, then they have not availed themselves, the former wife did not avail herself of the relief that she's now requesting for the first time, which is relief in the form of a liquidated judgment, because again, that judgment, the amount of that, cannot be achieved. And in addition, going sort of backwards in time, if you will, to this issue of whether it's void as a penalty. I agree with Your Honor that this is not the paramount argument that the former husband is making, this void as a penalty, because ultimately what this case rests on is what the trial judge articulated as a basis not to enter the order. The trial judge articulated clearly that he was not exercising his discretionary contempt powers, that what had been pled was for civil contempt, what had been argued was civil contempt, and what he was declining to exercise was his civil contempt powers. However, beyond that, it was argued ad nauseum at the trial level that this amount is void as a penalty. And again, I would point to the fact that it's the instant breach. When you're giving the test for whether something is a penalty or a liquidated damage provision, you're looking at the instant breach before that particular tribunal, and it was a $1,250 payment that was 11 days late, where the former wife could not articulate a single dollar of actual damage when she was asked to do so at hearing. There was not a single dollar that she could attribute to what happened as an ill effect to her in those 11 days. Clearly, the sums...
If there had been a determination, for example, that there was a $500,000 arrearage, but the parties then entered into an agreement like this, which said, if you make these payments, $75,000 will satisfy it, but if you default, I'm entitled to a judgment of $250,000. Would that be a penalty because it's disproportional to the $1,250 payment that was missed? Or would it not be such because it's been established that you actually owed $500,000?
That's a great question. If it was established that there was an actual breach resulting in $500,000 owed, I would concede the point that then you would have a related issue. But the distinction between this case and that factual scenario is that, first off, the agreement did not set forth any specific amount of money as a previous sum owed. There was never an agreement as to, yes, he did owe this greater amount, and any amount greater than $70,000. Secondarily, this isn't as if there's a breach of a previous agreement. This is a support matter that was subject to modification, where the former husband had specifically requested that the trial court modify that obligation. And it looked at both a prospective and retroactive support obligation and settled all things at one and for a set figure of $70,000. So it's not as if Mr. DUVALL had engaged in a prior breach. He had the discretion of the court and the appropriate pleading such that he was seeking relief of the court to reduce his obligation because of changes in circumstances which he sustained that were involuntary, unforeseeable, in keeping with the standard.
Were there arrearages that accrued before he filed a motion for modification?
I don't think that those were ever articulated with specificity, and I do believe that that there may have been some level of arrearages, but those were never put in forth the record with any amount of specificity showing that those arrearages are any way greater than $70,000.
Modification was never granted, correct?
The modification never needed to be adjudicated because of the parties' resolution on their own of those particular issues. But there was not a preceding breach that is then being cured with this agreement. It was something subject to competing claims. And again, that takes us back to the fact that this was all years and years before. And ultimately, what we're looking at and what the case law dictates that we look at is the instant breach, the harm from the instant breach.
I don't think you're right on that either. You know, if they claim that your client owed $500,000, and they took the position that they didn't think your modification petition would be granted, and that was their best case scenario, was $500,000, and your best case scenario was, you know, you only owed $10,000, $20,000, maybe zero, that your petition for modification is going to be granted, and you all don't know if the petition is going to be granted or not, so you reach a settlement, and the settlement is, you know, $70,000 as long as you stay current under this payment schedule, but otherwise $250,000. I mean, is your argument that that is per se an illegal contract?
I do believe so, Your Honor, that when you have that situation, you put such a heavy weight on deterrent for future breach, yes. But I also don't think that those...
But it might be favorable to your client because they may have owed $500,000. And now their worst case scenario is $250,000, their best case scenario is $70,000.
Yes, I understand.
Why isn't that like the settlement of any case?
Like the settlement of any case, Your Honor?
And you just put in a, you know, some caveat that if, you know, that you got to pay, or condition that if you don't pay this amount by this date, then you got to pay more because we don't want to have to litigate again.
Well, certainly, Your Honor, if there was a situation that said that if you don't pay, then we go back to some, you know, set aside the agreement remedy or to some discernible amount that is agreed to have been owed, then certainly. But if it's not an amount that's agreed to be owed, if it's not setting aside the whole agreement, and if it's just an arbitrary figure that's been tied to nothing, that acts as no more than...
It's not an arbitrary figure. It's a figure that's been reached as a compromise between the amount claimed by one side and the amount alleged by the other side.
But that figure, which is the compromise, is $70,000. There is nothing to indicate that the $180,000 was ever actually owed, nothing to indicate that was actually a vested arrearage. It is simply a figure...
Well, if the figure is $250,000, but your client got a reward for paying early and only would have to pay $70,000.
Well, Your Honor, I don't believe that he is, in fact, to be considered paying early because he did pay this over a course of time, which just ended recently.
Well, no, but how about the parties agreed that the debt was $250,000, but if your client paid on a certain schedule in a timely manner, then when your client reached $70,000 in a timely manner, then the debt would be forgiven.
The court's latitude to answer the question given that amount of time?
Yeah, go ahead.
Thank you, Your Honor. Yes, I think that that's different than what we have here because it wasn't as if it was set up as an incentive to pay early. It was a penalty from paying late. There was no...
We don't know that.
I'm sorry, Your Honor?
We don't know that. We just know that if you paid, your client paid according to schedule was $70,000, and if your client failed to pay according to schedule was $250,000. We don't know if it was an incentive or penalty, do we?
I don't believe you can read into it as an incentive because there's a case law, I think, that suggests that, and I'd have to double check the citation of the case, but I believe it was from the Supreme Court where they said ordinarily you look at this and you presume that if there's this deterrent that it is a penalty. and that's what courts ordinarily do with that. Thank you. I appreciate Your Honor's time.
May it please the court. This court decided in the case of Crosby Forest Products versus Byers back in 1993 that it does not violate the public policy of the state to enforce a settlement agreement where a larger amount is payable upon default, especially if the larger amount is supported by the record, as is the case here. In fact, Mr. Wendell just argued at length as to why this agreement should be enforced as it was written, because there was negotiation and litigation between the parties. Mr. DUVALL claiming that he should have some sort of modification, Mrs. DUVALL claiming that she was owed $647,000, and they reached a negotiated settlement that was approved by the trial court. The same judge who later would not uphold the settlement that he had approved and argued and ordered the parties to comply with, let Mr. DUVALL yet again have a mulligan and get off the hook. But all of this is a collateral attack on a stipulated agreement to which an order was entered and no appeal was ever taken from it. So to come in here now and relitigate these issues is a collateral attack.
Let me go back to the contempt issue. Do you have a copy of your brief there?
I do.
All right, yeah, look at issue 2. Yeah, I have it here. Do you want me to just read it to you?
Sure. Actually, here it is. Had to make sure I had the right folder.
So you argued
go ahead.
that it was error for the lower court to refuse to enforce the stipulation based on legal principles applicable to contempt, where the remedy sought was the entry of a judgment in accordance with the agreement of the parties. Now, is it your argument to us that even though the motion said motion for contempt and enforcement, even though the wherefore clause asked for incarceration and purge amount, that the trial judge erred because he should have known that the remedy sought was the entry of a judgment?
Yes, Your Honor. And I'm glad you asked that question. Because what happened in the lower court? The parties understood what was being asked for. The parties understood what was being litigated. There was no argument made by Mr. Wendell that we were asking for contempt or the incarceration of his client, or that this was governed by equitable principles. He argued, one, that his client was not late, his client was a month ahead, which was specifically rejected by the trial court. Two, he argued, as he argues here, that it's an unconscionable penalty and that we should have been limited to, quote, the actual damages suffered as a result of that late payment. Those were his arguments. And those were, as he said, the arguments he made ad nauseum. It was the trial court that came up with the contempt argument.
Perspective. Is there any reason, wouldn't it have been better to simply said, you know, we asked for entry of a judgment?
Absolutely, it would have been better.
All right.
Absolutely, I cannot argue that.
Is the trial judge wrong for relying on what you put in the title and in your wherefore clause?
Yes. And the reason why is because what was argued to him by both sides.
Invited error?
What's that?
Is that an invited error?
I don't believe so. And we made a general prayer for relief. The affidavit that was incorporated into, which by the way set forth the amount that was owed as required by the stipulation, it very specifically said what the wife is entitled to is $250,000 minus the $31,000 and change paid to date for judgment in the amount of, and it spelled out the relief that we believed we were entitled to, and again, the motion itself, paragraph after paragraph, quotes the provisions with regard to the entry of a judgment. At no time did anybody say, Your Honor, Mr. DUVALL should be placed in jail, or that we should receive anything other than that judgment. Yes, the motion was inartfully drafted. I will grant you that. But, you know, we have principles in this state where if we were to have gone into, for example, a trial and tried certain issues by consent, the parties would be bound what was tried by consent without objection. And I think that's why it's important that the parties understood what was being asked for. The parties understood what they were arguing. Mr. Wendell's arguments went directly to the issuance of the judgment or not. It was the trial judge that settled upon those particular issues that frankly would allow him to not enforce the terms of the settlement for reasons I think have absolutely nothing to do with the settlement itself, but more has to do with the settlement of the other case that was pending at the same time with regard to the adoption of the youngest child, as indicated in the court's footnote where he talks about the story of Solomon and the splitting the baby. And with all due respect to Judge Takis, I think he settled on the contempt issue as a way of, you know, sympathy or relief for Mr. DUVALL in this particular set of circumstances.
We don't agree with you, and we choose to affirm the trial court's order. Is the appellee entitled to appellate attorney's fees as prevailing party under the contract?
You know, we prevailed in the trial court, and which, by the way, is one of our issues that we have raised on appeal. The court acknowledged that Mr. DUVALL was late, that he missed that payment, that it was a unilateral mistake on his part. The court ordered us to mediation. The court set multiple hearings, and then after the court says, well, yes, you're right, he missed the payment, but I'm not going to give you the judgment that you have asked for all these other reasons, and then he awarded a minimum amount of fees, essentially holding, despite the fact that we've been ordered to mediation, we've been ordered to multiple hearings, that somehow we over-litigated the case. So would they be entitled to attorney's fees if they're the prevailing party or cited a particular reason and they prevail on appeal? I suppose so. But by the same token, with regard to the last issue we raised, we should get more attorney's fees in the trial court than what was awarded, because the evidence, they stipulated the hourly rate, they stipulated to the amount. We prevailed on the issue of breach. The court found expressly that there was a breach. We were required to attend mediation. We were required to attend multiple hearings. So at the end of the day, yeah, I suppose they might be entitled to fees on appeal if they were to prevail, but by the same token, we should be entitled to our fees in the lower court, and we were awarded a minimal amount of fees merely for preparation of the motion. As for the idea that somehow, you know, they had processed the payment, I submit that that payment was made in response to receipt of the motion and realizing that he had failed to make a payment. With that, unless you have another question, I am finished. Thank you very much.
Next case.